Good morning. Good afternoon, Your Honors. The matter before the court this morning is the case entitled In Re KW, case number 23 AP 218. Representing the appellant, CW, is attorney Sarah Starr. Representing the appellee, State of Vermont, is attorney Jared Bianchi.
Thank you very much, and good afternoon, counsel. We'll hear from counsel for the appellant first. Of course, please introduce yourself, identify your client, and then proceed.
Good afternoon. I'm Sarah Starr, and I represent the appellant mother, CW.
Thank you.
The court and the parties in this case really lost sight of the purposes of Vermont's child welfare laws. And the welfare of the child is paramount and not the punishment of the parents. And in this case, there was no dispute that the child was Chin's, but still extremely contentious litigation ensued anyway, to the detriment of the parent-child relationship. And the procedure that the court used here really abetted this breakdown. Parties.
Does it matter if it's a Chin's A or C, Ms. Starr? And does it make a difference on how it gets, what the finding is on Chin's?
It really doesn't, and especially because the disposition statute specifically allows for a stipulation for what issues will be addressed at disposition. And so, I mean, I think there are some cases where a disagreement on the facts might be a problem at disposition, like for an unacknowledged sex offense or an unacknowledged substance use problem. But this is the type of disagreement, a jab in the arm is not something that's gonna, that this is not something that's insurmountable for social workers to work with a family on at disposition, even if the facts aren't agreed to. So it was not appropriate to use this procedure. I mean, if there was a significant enough issue that it needed to be litigated, there wouldn't have been a stipulation, and the court shouldn't have accepted the stipulation, and then the facts could have been litigated. But really, this was the mother didn't want to lose her job, didn't want to lose her home or her livelihood because of an allegation that wasn't true. And the state was laser focused on proving that this punch occurred. And, that is what this case became about.
So it does matter if it's a, excuse me, it does matter if it's an A or a C. I mean, an A would be an unmanageable 15-year-old, and a C would be the abuse. I mean, if it was A, it was that the child was having a difficult time at home, which many teenagers do. It's not unusual. And then the mother potentially needed some help in managing the child's needs.
I mean, yes. I mean, and I think that whether a punch occurred or not, the evidence would show that the mother needed help managing the child's needs, because even if that did occur, that was not an appropriate response to an out-of-control child. That doesn't mean, and there was no analysis that rendered the child Chin's A due to abuse. And so Chin's A due to abuse is something very different from, what we have here, which was a mother who couldn't get her child's behaviors under control. And so this really was appropriate and that's why there was a stipulation that this was a C. And the state simply didn't meet its burden to show that it was an A, and the focus on that this was also an A because of the additional act of one hit or punch. The court wasn't totally clear. It just, I mean, by the time the case was over, the additional adjudication made no difference in the case plan except to account for the breakdown of the relationship that occurred over the litigation. So I'm not sure if I have any time left, but I'd like to reserve some if I have any.
Understood. Thanks very much. We'll turn to counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Thank you, Mr. Chief Justice and Justices. My name is Jared Bianchi. I'm a Deputy State's Attorney from Bennington County, and I'm representing the state of Vermont in this case.
Thank you.
At this juncture, Your Honor, we believe that our argument is fully set forth in the briefing. I believe that we've responded to those points. I'm happy to go over them again, but I think that maybe the best use of this time would be to say that we would rest on our brief unless the court has any particular question.
Well, Mr. Bianchi, again, I'm sort of, I don't mean to be hyper-focused on one issue, but the fact that it was fairly undisputed that the child was unmanageable. And without pointing fault on anyone or dealing with it. It's a 15-year-old who's having some difficulties at home. And now, again, that's not uncommon. It's the extra part. It's the contact between the mother and the child, where the dispute seems to have gone down a different road.
That's right, Your Honor. And I think it's important for the trial court did make some relatively, did not ultimately feel that it had to make all the findings that were sort of captured within some of the testimony. But I wouldn't agree that the issue here was a jab. What we had here was not something that could be simply resolved by the disposition plan, because it wasn't, it was just a jab. It wasn't that big of a deal, sort of a factual dispute. It was this didn't happen. The other party is making this up as a plot to get away from the parent as a caretaker, essentially, was the defense. And so to send that case to disposition without being able to resolve that core concern about whether the subject juvenile was in fact safe, even if she became, even if she were able to resolve the challenges that were causing her to be Chin C, whether that core issue was something that needed to be worked through on the case plan, needed to be resolved because of the degree to which there was a factual dispute about what happened and some of the surrounding facts around that. So that was why it was necessary to resolve that. Both of these were part of the petition when it was filed. This wasn't a situation where we are seeking to backfill anything by calling it a different type of chins. There was notice, there was robust opportunity to be heard, and so for that reason, Your Honors, we have continued to persist in saying that this is really no different than chins being a truancy, which can certainly happen plenty of times, because a lot of times the issues that are leading to one form of chins are issues stemming from another. So we believe that it's appropriate, when they are properly noticed, to be able to proceed and to provide the full set of facts to the court and have those adjudicated through the process that's available. And so if there are any other questions, I'm happy to answer, but otherwise, Your Honors, I would rest.
Okay. All right. Thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 21 seconds remaining.
Counsel?
So the state argues that there were findings that the court did not have to make, but that the evidence was presented, and the court does have to make findings. I mean, if the state's argument is that there were more findings needed in order to proceed and have an effective disposition plan, then the court should have made findings beyond that. When a parent strikes a child and leaves a bruise, that is always abuse. The court did not make any findings about what impact that act has on the child or had on this particular child. I mean, the impact could have been anything from she was upset by it to she was happy that her mother did it because then she could use it as a way to stay out of the house. I mean, the act could have had any number of impacts on the child, but the fact that it happened did not mean that she was an abused child within the meaning of the statute.
Or the complicating thing in all these, I'm sorry, Chief, if I can just.
Oh yeah, please go ahead.
The complicating thing is with a 15-year-old, where, I mean, what's the consequences? Ultimately, you're not going to put the child up for adoption. You're not going to make the child, you know, I'm blanking on the word, but so you still have to work out a system where you're trying to the family back together, are you not? I mean, what else do you do?
Exactly. So that is why I think in cases like this, when everybody agrees that a child is Chin's C because she was beyond her parents' control, that really moving to disposition and moving towards reunifying is really important. And not, again, like, if there was something else significant like sexual abuse or something like that that was going to prevent reunification, but here it was the litigation itself that prevented reunification. And so I really think that this process was beyond the scope of this statute. You're not allowed to stipulate and then also litigate at merits. And it really was to the detriment of the family. And also, I mean, I've just lost my train of thought and I'm probably out of time, so I'll just stop there.
All right. Okay. Thank you. Thank you very much.